name is Sarah Runcie and I work in policy and strategy here at the APA. And it is my very great pleasure and honour to introduce our two speakers today, Fiona Phillips from the Australian Copyright Council and Libby Bolsch from the Copyright Agency. This is our third webinar on fair use and fair dealing. And for those of you who have been joining us for the last two, you would have gone through an introduction essentially on our current system of fair dealing and an introduction on fair use, where it's come from and so on. One of the key elements in all of this is kind of having a sense of legal etymology, if you will, on some of the terms like fair dealing, like fair use, what the four factors are, etc. And we hope that you've been able to get a reasonably solid understanding of these basic terms and where they come from and their legal meaning. Today, what we're really looking at, though, are the current debates and where they've come from, what the issues are and what the arguments are. Just as a bit of background, though, I should say that really our aim here is to get, as an industry, a better understanding of copyright as a key infrastructure to the publishing industry and indeed all creative industries. And but as just a bit of background as to where all of this began, on the 20th of December last year, the Commonwealth Government released a final report for the Productivities Commission's inquiry into Australia's intellectual property arrangements. The release of the report has reignited debate regarding the fundamentals of Australia's copyright regime. The report itself is very broad, covering everything from plant breeder rights through to patents. And encompassing, of course, copyright. The APA position has been to oppose the Productivity Commission's recommendations on issues such as fair use and also the removal of parallel importation restrictions, the campaign of which you may be aware of, that ran for much of last year as Books Create Australia. So in this webinar, we're really looking at the arguments, which is bringing together some of the fundamentals that we've been well schooled in now by Ian McDonald of Simpson Solicitors, and to bring this together in terms of how these issues are live currently in debate. So let me just introduce our speakers today. Libby Bolsch is Policy Director for the Copyright Agency. Libby has been Policy Director since 2009, and a role that includes a whole range of copyright-related issues, including the accessible format issues. And Fiona Phillips, who is Executive Director of the Australian Copyright Council. Fiona is a copyright expert with some over 20 years, or actually collectively, how many years of experience in copyright would you say? What are we up to? A lot. A lot. A lot. Decades. And also, I should say, one of the things that we will be talking about, which Fiona was deeply involved in as well, was the ALRC process and report, which some of this actually has support for. So with that, I'd like to jump in straight away to one of the key issues, which was with the ALRC report. The ALRC report came out in 2012. Now, there was actually a moment prior to that, which was in 2006, I think, where fair use was raised and rejected by the government. So it was 2012 the next point in which, if I have it right, 2012 was the next point in which the fair use debate was reignited. Is that correct in terms of time frame?
Yeah, that's pretty much right, Sarah. So it actually even goes back a little bit before 2006. So there was this report by the Copyright Law Review Committee back in 1999.
So everybody can see it now. Yes, visual interest here.
Yeah. 1998, which looked at exceptions to the exclusive rights of copyright owners. And the committee actually did, in this report, recommend a form of open, fair dealing. Then nothing happened with that. And then what happened in the interim was the free trade agreement with the United States. And there was a feeling coming out of that the treaty had strengthened, increased the rights of rights holders, query or not whether or not that is the case. But there were things like the extension of the term of copyright, and some changes to the criminal sanctions for rights holders. So there was a feeling that the balance had shifted in favour of rights holders, and so this caused, I suppose, some lobbying for fair use to be reconsidered. And it's like, well, if we're going to have the exclusive rights that they have in the US, we should also have the exception. So that led in 2006 to the review that the Attorney General's Department conducted. And while fair use was rejected, that did result in a number of significant exceptions being introduced into the Act at the end of 2006. A new fair dealing exception for parody or satire, which actually came directly out of case law where in the US where that had been a type of fair use. And importantly, the private copying exceptions relating to format shifting, and importantly, Section 200AB, which is the flexible dealing exception for key cultural institutions, educational institutions, and people assisting those with disabilities, which is supposed to apply when there's no other exception. And in reality, Section 200AB is akin to fair use, but it only applies to certain sectors as opposed to the world at large. So that was 2006. Then, as you said, we had lobbying continuing, and that resulted in the ALRC inquiry in 2012. And at the end of that, beginning 2014, the ALRC came out with this. This is a summary of their report. And they recommended introduction of fair use, or failing that, an expansion of fair deal.
Okay. Because the ALRC report has been quite influential. But to go back, so the ALRC report was triggered because fair use hadn't been delivered in that 2006.
Exactly, and there was feeling that the flexible dealing exception in 200AB had not been taken up by stakeholders, and that there was that it was too difficult and there was a better way forward, I think. And also there was at the time there was some controversy around the Optus TV Now decision, where which people might recall, this was where Telstra had the rights to stream the AFL and the NRL. Optus developed an app whereby there was seeking to rely on a private copying exception, whereby there was a slight delay, but it essentially bypassed the need to license. And people saw that as a demonstration that our exceptions were too specific and not allowing the latitude. I don't think that is the correct analysis, but that was part of the criticism at the time, that our exceptions were too specific. They did not accommodate innovation such as this app.
The Optus app.
Yeah.
Okay. And you were involved in the ALRC process. I was wondering if you could give me a comment or two regarding that ALRC process.
Look, the ALRC process, it was only looking at exceptions and limitations in the Copyright Act. And I suppose as compared with the PC, it was looking at from a legal policy perspective rather than, didn't really have, even though they expressed a commitment to evidence-based policy. I think one thing that we all experience as stakeholders is that we went through a lot of effort to provide data and evidence, and then the ALRC was not really equipped to grapple with that in a meaningful way. My involvement, apart from as the head of the Copyright Council and helping stakeholders to formulate their views, was as part of their advisory panel, which was made up of about 20 experts. I suppose the thing that was somewhat controversial was that I was the only rights holder representative as part of that panel. That, to me, demonstrated kind of the naivety, perhaps, of the ALRC, that they didn't realise how highly political these issues were. So I think that did diminish the report in some ways, that they didn't have a better representation of stakeholders on the advisory committee. Having said that, I don't know whether the advisory committee had such an influence on the outcome of the report. Maybe some ways, and obviously I'm limited in what I can say about the actual process. So yes, that was unfortunate. As we all know, perception is very important in these processes, so I think that did diminish the report in that way, but query from a substantive point of view whether it really made a difference to the outcome. And certainly the ALRC report, while we might not like where it came out, it's like chalk and cheese with reading the PC report, which is so kind of ideologically charged. And I think that's very, very clear.
That's very interesting, because so if and this is to throw to both of you. So basically, what were the fair use recommendations with the ALRC report? Because really what I want to get to is, how did that influence the PC recommendations? So what were those recommendations in terms of the ALRC report?
Well, the ALRC did recommend the introduction of an exception for so-called fair use based on the exception in the US, and adopting the same 4 factors as in the US legislation, which are actually quite similar to factors that we already have in Australian law for fair dealing for research or study. So the factors themselves are not alien to the Australian environment. In Australia, we have an additional factor, which is the commercial availability of the content. So that's one of the things that you have to check before you can make a fair dealing for research or study. The difference, as I think has been talked about before, is that in Australia we have a sort of 2-step process, where first you need to look at whether or not what you are doing is for one of the prescribed purposes. So these are purposes that Parliament has decided are beneficial to society, like research or parody or criticism or education, things like that. And then you look at the conditions, and in some cases the conditions are similar to the factors in fair use. But with fair use, there are no prescribed purposes, and so all you are looking at is the factors, and not whether or not what you are doing has some societal benefit.
So I suppose the controversial thing about the ALRC recommendation is they also they said it should be an open exception, but they also suggested the inclusion of a whole long list of illustrative purposes. So that those would include the things we currently have in our legislation, like research or study, criticism or review, parody or satire, news reporting. But then, if you allow me I'll just give you its quotation: non-commercial private use, incidental or technical use, library or archive use, education, and access for people with a disability. So the last one obviously is something that the government's taken up in this latest bill that's currently in Parliament. But, things like fair dealing for education and for library and archive use, and also incidental or technical use, because that would cover things like text and data mining, would have potentially huge impact, particularly for the publishing industry.
Mm.
And maybe the other thing to say about the ALRC that does distinguish it from the later Productivity Commission report is that the ALRC anticipated that a recommendation for fair use would be highly controversial and would involve positions put by a range of interests. And so it also recommended a plan B, if you like, which is introducing some new exceptions connected to fair dealing for the activities that Fiona just listed. So some of those are already covered in our current legislation. There are provisions for technical uses, for example, but some of them would be new, such as an exception for quotation would be a new thing. Text and data mining would be a new thing. And importantly for education publishers, if you had either fair use or fair dealing for education that intersected with the existing licensing arrangements, then there is the potential for a severe reduction in the licensing fees that are currently paid by the education sector to authors and publishers via Copyright Agency. And that has been the experience in Canada. The changes there were slightly different, but those changes did result in the education sector ceasing to pay the licence fees that they paid previously.
Mm. So moving to the PC report now, and for visual aid, we have it here, and perhaps we need to show how thick it is. That's, yes, at least 700 pages worth of work there. And I mean, you've talked about the ALRC report and how it is different to the PC, or PC report, how it is different to the ALRC report. Can you comment on what they actually did adopt from the ALRC report?
So it's interesting because this is where there was a change between the interim report and the final report. So in the interim report, the PC put forward their own version of fair use, which was not like anything that exists in the US or indeed in any of the other jurisdictions that have adopted their own version of fair use, like Singapore or Korea or Israel, for example. And I certainly made the observation that I didn't think their formulation would meet international law, but interestingly, academics who tend to have more of a user-oriented focus also thought that perhaps wasn't the best way to go forward, and suggested that the PC adopt the ALRC model. So that's why you see in the final report, pardon me, that basically the PC has adopted the ALRC model of fair use, not fair dealing, so not the fallback that the ALRC recognised in its entirety. So they haven't done their own formulation. So so the recommendation coming out of the PC is essentially that which Libby and I explained before. So it's fair use with the 4 factors as in the US, but then with a long list of illustrative purposes, which will not necessarily say that if you're doing something for one of those purposes, it will amount to fair use, but it certainly creates an assumption in favour of those kind of usages.
Mm.
I might just talk about one other recommendation here, which hasn't had a lot of coverage so far, but it can be important to publishers, and it's what's known as contract override. And what it means is that For example, if you have an online subscription offering as a publisher, and you'll have terms of use that are connected with that subscription offering, and usually the terms of use will say you can do these things. You can make the content available to these people who are covered by the subscription arrangements. You may be allowed to print. You may be able to make available in other ways, and then often there will be prohibitions in the terms of use whereby you'll say, well, you can't do this and you can't do that, and you can't supply to people who are not covered by the subscription arrangement. So the Law Reform Commission recommended that in certain circumstances, if you could use the content under an exception, then you could ignore those contractual arrangements, those terms of use. So you could override the subscription arrangements in order to rely on the exception. Interestingly, the Law Reform Commission said that you would have this contract override for the fair dealing limit, the listed fair dealing exceptions, but not for the broader fair use recommendation. So that was sort of interesting. They thought it was different, having these a contract override for these sort of societally beneficial purposes listed, but not necessarily for the broader application of fair use where you can get quite large-scale commercial uses. The Productivity Commission, sort of in line with its more perhaps hostile approach to content industries, recommended that you would have this contract override in all cases where you could use the content under an exception in the Copyright Act. So that's a little bit of a a little bit of a sleeper issue, but it is a big issue in other jurisdictions. It was in the UK, it is in Europe at the moment, and it's likely to be raised again in Australia as we discuss these recommendations more.
That's actually a really significant issue. So this is perhaps a digression, but there is some debate around this, and we can probably touch on this in more detail later, but there is at least some people saying that introduction of the fair use will mean the end, ostensibly, of the statutory licence, and others that say no, it can perfectly coexist. So does the contract override, impact on the statutory licence?
I hadn't given that a lot of thought, to be honest. I guess it would mean that you could rely, if you're covered by the statutory licence, then you may be able to rely on the statutory licence even though your subscription terms said that you couldn't. So that is true. But maybe even more importantly, if it's a free exception that you can rely on, and even though the terms of use prohibit you from doing that, you could go ahead and do that.
So the question becomes, why would you have a statutory licence under fair use?
Well, the issue with sort of coexistence of fair use and the statutory licence is really to do with the size of the discount. So at the moment, the school sector say that they are looking for a discount in licence fees of about 30%. So they've been asked to quantify how much less they want to pay, and they've said they want to pay $18 million less. So that's 18 million out of about 60 million that's paid. That's to Copyright Agency at the moment. The concern is that there were similar undertakings given in Canada before copyright changes there, and the Education Authority said, well, of course we'll continue to pay licence fees, and in the end they decided not to. And the guidelines in Canada that the Education Authorities are relying on to avoid paying licence fees are pretty similar to the amounts of content that can be copied under the statutory licence at the moment. So the Canadian guidelines say you can copy a chapter or 10% or an entire image or an entire poem for free, and at the moment all of those activities are covered by the statutory licence.
So just to go, we'll probably come back to the statutory licence and fair use, but just to go back to the PC report and their arguments for fair use, why did the Productivity Commission think that fair use was such a good idea in your view?
It seems that their view seems to be informed by their view on a distortion of the balance. So they very much focused on the extension of term of copyright from life plus 50 to life plus 70, and said that because of that, there needed to be a redress of the balance, and they saw fair use as the essential. I think Commissioner Chester spoke at the ADA forum about it being not a nice to have, but a must have. So that seems to be the basic rationale behind it, that it was a way of restoring some leverage to copyright users.
Yeah, I would agree with that the Productivity Commission used some ABS data to argue that the average commercial life of a copyright content-based product was 5 years. So they thought that in an ideal world, the maximum protection that you would have for copyright content would be 15 to 20 years. They recognised
15 to 20 years from creation.
Yes.
So not from death of the author. It was 15 to 20 years from the creation of the work.
So to give you an example, a real life example, I was listening on the radio on my way to work this morning about the new television program made out of Elliot Perlman's book, Seven Types of Ambiguity.
Yeah.
That book was published in 2003. So that means now that it's, arguably, if you'd waited another year, you wouldn't have had to license the rights in order to make the TV program.
So I think that the Productivity Commission did recognise that it couldn't recommend in the short term to reduce the term of protection because Australia is a party to a whole lot of international treaties where we've agreed to at least life plus 50 and in some cases life plus 70. That they were, I think, frustrated by that. And so they were really looking for other ways to intervene to reduce the level of protection in other ways. And so for them, fair use was a way to reduce the level of protection, given that they couldn't reduce the term.
Yeah. And certainly the finding that the Productivity Commission made about copyright duration has been heavily criticised by the content industry. I won't go into those criticisms, but the Australia Council particularly did a lot of work in their submission in relation to copyright duration and how they felt that the way that the Productivity Commission had approached duration was incorrect. I think it's probably the executive summary on that, but I think that there was a very apt question that Garth Mix asked in the Productivity Commission hearings when they talked about the duration finding. And his question to the commissioners was, what do you call an average book? What's an average book? And his point being that their whole analysis was based on there being an average artwork or average book or average piece of creative content, which I think just intuitively is a bit of a nonsense. But we won't go further into that discussion, but if anybody does want further information about it, I would highly recommend having a look at the submission on that.
I think it's, I was going to say, it's also worth challenging them, I think, on this whole concept of the copyright reform process over time has benefited rights holders and not people who are getting access to content. So if you actually look at the history of copyright reform, there haven't actually been that many increases in scope. The extension from Life Plus 50 to Life Plus 70 was very controversial, and that's the one that people know. But apart from that, there have been really not many other extensions in scope sort of across the board. And every time there has been, it's either been accompanied or followed by new exceptions and new access regimes. And in fact, there are a number of studies by the World Intellectual Property Organisation, comparative studies that have looked at Australia compared to other countries, and Australia is really at the top of the list in terms of its exceptions and access regimes. That access for people with disabilities, accessible formats. Australia was really a world leader in providing an access regime there way back in the 1980s. And so this sort of whole idea that in Australia the copyright regime has moved inexorably in favour of rights holders and against the interests of users is just wrong. But it was an underlying premise for all the recommendations that followed. So, there is a good case that the whole report was based on some faulty premises.
I think a good example would be all the library and archive exceptions that we have in our Copyright Act, which largely reflect our geographic circumstances, that they were designed to access distribution of books, hard copy books, in a large and disparately populated country, which arguably those same circumstances don't exist today. So, it's interesting.
It is. And I think we've probably stepped into the core of the discussion that we want to have today, which are the arguments for and against fair use, for and against fair dealing. But so I want to step into the fair use debate now and ask, independent of what the Productivity Commission recommended, there are many arguments that are made for fair use. And no doubt we've heard discussion around flexibility, tech neutrality, which means that you're not talking about your VHS, VCR, recorder when you've moved to Blu-ray or something similar. You're talking about a lot to do with what people bandy about, which is innovation. So I wanted to ask you both, what is fair use meant to solve that will enable innovation? And what does that mean? It's a big question. Maybe we could break it down.
I might just start with maybe one sort of comment that sort of comes out of looking at what I think are the drivers for fair use, which are actually not all about innovation, but then we can go on to talk about the innovation thing. So there's one...
well, maybe we should talk about flexibility then first, because that's one of the attributes that people talk about in relation to fair use. So maybe we can talk about flexibility first, because I think flexibility is meant to be something that assists innovation.
But I think, just to step back from that, I think that there is a whole group of submissions that talk about what I would call sort of minor infractions or trivial uses of content that really nobody bothers about too much, but there isn't an express provision that says go ahead and put this image in your PowerPoint presentation, or create a meme from this image, or that sort of thing that are minor, nobody cares too much about, but they're not easy to slot into a sort of specific
And
section.
Lord knows we don't have enough memes.
We don't have enough memes. So I think
Especially
that's,
involving cats.
Yeah,
so
we need more cat memes.
So I think that's one driver, which is not really connected to innovation at all.
Right.
There's a second driver, which is quite specifically about reducing licence fees. So the submissions from the education sector, they talk about things that they can't do under the current regime, but in fact, when you question those, you find that in fact there's not much that they can't do, if anything, and really it's about the value of the use. So it's not about barriers to access to content or not being able to use stuff. It's really about what's the value of that and how should the level of compensation be set. And then
Which is not a copyright issue per se. It's using copyright in a commercial negotiation.
Well, it's about distribution of resources, and so
I'm going to bring you closer in again because I want people to see your fabulous glasses, amongst other things.
So it's about distribution of resources and how and what priorities you place on them. So arguably, I would say a system which facilitates access, which also allows the authors and publishers to receive appropriate remuneration, is a good system, rather than a system that facilitates access and leaves authors and publishers out of the picture. I would suggest is perhaps a little bit short-sighted in terms of investment in the creative sector, particularly when you're talking about local creative products. So and even supporters of fair use. For example, I was on a panel at a conference in the States last year with Judge Laval, who is the famous fair use judge in America, and he even acknowledged that maybe our statutory license system, as it functions here, serves the same distributive purpose, that it's actually a better deal for everybody rather than a winner takes all.
That's a very interesting point.
And I was going to say that the third thing I think is the really big difficult policy issue, which is about new, particularly online business models that are based on content inputs. So the business model may not be about the sale of content. It's usually about, at the moment, advertising or collection of personal data. But those business models do rely on content inputs. Some of those are amateur content and people are happy to give that content away, but not necessarily. Some of it is what I would call professional or commercially produced content. And so there is a big policy issue about whether or not the people who are investing and creating in those content inputs should be entitled to some form of compensation for the value of those content inputs to those new business models. And I think that is sort of really the crux of it. Having said that, if you look at government reports, for example, from the Department of Industry about barriers to innovation and what's getting in the way of startups in Australia, none of them mention an unfriendly copyright regime. They all talk about things like risk aversion and lack of venture capital and lack of expertise, and none of them have copyright anywhere front of mind when they're looking at these startups. So I think a bit of a reality check in what are the real barriers to Australian startups is sort of helpful in this context.
Do you want me to play devil's advocate for a second?
Yes, and in fact, yes, I was going to say let's play devil's advocate to that, because it is a very common argument with regards to fair use that it will facilitate better as a copyright regime innovative use of copyright material?
So what people argue is that unless you fit into one of the current fair dealing purposes or one of the exceptions, for example, the private copying exceptions, then the answer is automatically no. You can't do that without a license. And maybe a startup doesn't have the wherewithal to get those licenses up front. The argument in relation to fair use is that it's more likely to produce a result that says maybe, and depending on the risk appetite of the particular organisation, entity, they might be happy to run with that risk and take a chance and test it in court. And that's where the risk appetite really comes in, and that's where you have, for example, educators and libraries are traditionally quite averse to risk, whereas your tech entrepreneurs are willing to, they have a high risk appetite by their very nature, and so to me, so that's what the argument is, that there's going to be more greyness, and that you could use that grey to the advantage of innovation rather than having an outright no. You would, and what they say is it would have to be fair in any event.
But maybe it might be worth talking about the Google Books digitisation project as a case study. I do think that's quite an interesting case study. So some of the people participating may remember the Google Books digitisation project. And what happened was that Google decided to just start digitising millions of books on a sort of a crash-through basis. And in the end, I was sued by authors and publishers and came to a settlement arrangement that would have set up a distribution channel for digitised books and have delivered revenue back to the publishers and the authors. What happened was that settlement arrangement needed to be approved by the courts in the US, and it failed for lack of a legal infrastructure to enable that settlement arrangement to proceed. So what happened after that was that Google then had to go back to, directed by the courts, back to arguing that the digitisation was allowed by fair use. It had to really de-scope its ambitions, if you like, and it de-scope what the project would deliver to consumers in order to meet the requirements of fair use. And in the end, controversially, the court found that the particular setup for Google Books did meet the requirements of fair use. There were a lot of security measures in place, etc., that enabled it to meet the fair use requirements. But arguably, the consumer, that everybody was a bit worse off. What the consumers got wasn't as good. There wasn't money going back to the authors and publishers.
There was an incomplete text.
Yes.
They were incomplete text.
And I think, interestingly, the Copyright Office in the US, an arm of the executive government, looked at these mass digitisation projects, and it said that fair use is an inadequate solution for big digitisation projects of that kind. And what the US needed was a licensing framework similar to what's in place now in the UK and in France and Germany and a lot of Scandinavian countries, that would provide a framework to allow those digitisation projects to go ahead, but on a licensing framework that would deliver some compensation back to the content creators. So it's a lack of infrastructure problem.
Which I think is really interesting, and maybe it's only specific to the US context, but this gets us back to fair use and the statutory licence. And is there something about fair use that is kind of automatically hostile to the statutory licence as a thing, as a solution to these kinds of problems?
I do think you have to see the push for fair use by the education sector as solely about the licensing fees. It's not about access to content. Fiona mentioned before that in 2006 the legislation was amended to give the education sector essentially a fair use for education exception. So they've had that since 2006. The reason they don't like it is that it says specifically this applies where what you want to do is not covered by the statutory licence. So it operates outside the statutory licence. They want something that enables them to argue essentially a fair use discount, and really the issue is how big is that discount that they're going to ask for. I'm just going to say one more thing about it, which is that our view is that there is already a mechanism to determine value. So we have a copyright tribunal here. The fees are negotiated usually about every 3 years. And there's a whole lot of stuff that the education sector does where we say that's outside, that's not part of the remuneration arrangements, we're going to put that to one side. So a whole lot of internet content, for example, anything that's directly licensed by the publishers, anything that's Creative Commons, you essentially put that in the bin and you don't take that into account when you're looking at what's a fair value for the use of content. And if you can't reach agreement, then either party can go to the Copyright Tribunal, and the Copyright Tribunal can say, look, there are these technical things that the education sector is doing. They don't, yes, they're technical copyright uses and they're allowed by the statutory licence, but they're not things that result in consumption by the students, so we're going to exclude those from remuneration consideration. So we think there's already an infrastructure that allows those arguments about value to be put in a coherent way.
So to go back to that though, is fair use sort of hostile to that kind of infrastructure?
Yeah, I think it makes it difficult.
Not to personify a concept, but is it something that inherently doesn't work well with that kind of infrastructure?
I think fair use, whether you're talking about statutory licensing or other forms of blanket licensing, for example, that APRA might engage in relation to music.
Yeah,
I think that fair use necessarily changes the negotiating ground, the bargaining ground. So if, for example, a distribution platform can rely on fair use, that is automatically also going to reduce the license fees that they pay for material that's being distributed on that platform. So it's not so I think the statutory license is immediately relevant, but I think it also applies across the board. And an example would be for that, APRA licenses YouTube.
Yeah.
If they could argue that the material was covered under some fair use and that applied to YouTube as the platform as well as the users, then that would automatically change the nature of the bargain.
Yeah,
I think it might also be worth saying, and Ian might have covered this in his earlier webinars, that there's a sort of traditional fair use in the US, which was quite contained, and then over the last sort of 10 years or so, what you might call adventurous fair use in the US, where the courts have really expanded the application of fair use way beyond the bounds of what was in contemplation back in 1976 when it was codified into the US statute. So I should also say that that's not consistent in the US, which is part of the uncertainty problem. So some courts take a more adventurous position and some courts a more conservative position, but they have developed this idea of transformative use to mean, at a very extreme point, anything that you're not doing already we can step in and use your content for that purpose and rely on fair use to do that. And that can be difficult if you are, you've got a primary offering, but you are
have the back of your mind.
That's right. You have other forms of exploitation and contemplation that you want to look to invest to, and somebody else has stepped in and used your content and taken away that opportunity to develop those.
All right.
Those
so I'm going to be devil's advocate to a degree. One, and you talked about uncertainty in relation to fair use. Well, when people have difficulty interpreting our fair dealing law, they find it uncertain. So that to argue that fair use is more uncertain than what we have now, perhaps it's mixing two different things illegitimately. But one thing that I have heard more than once is how fair use represents a lawyer's picnic. My question to you, both as lawyers, is fair dealing a lawyer's picnic anyway?
What I would say is that there is a degree of uncertainty where you have to apply the exceptions on a case-by-case basis, but at least there is a clear statutory articulation of the purposes for which the exception would operate, and the factors that need to be considered. The issue in the States is that partly because of the way their legislature works, is it's actually very difficult to get statutes through Congress, and so in a way, fair use has become a proxy for specific exceptions. And so really what you then do is it's a rule of law question whether you have the law being made by Parliament, elected by the people, or by the judiciary. And it seems to me that in the state there's been a slant towards the judiciary. I think the other things that when you talk about the certainty factors is you have to look at their different legal framework in the states. So in the States, of course, they have the First Amendment. We don't have a Bill of Rights in Australia. So that automatically plays a role in interpreting the legislation. Secondly, their copyright power in their constitution is for science and the useful arts. In Australia, we have copyright power is just for, in our constitution, just for the peace, order and good government of the Commonwealth, so no particular kind of...
Well, the copyright debate would seem to have failed that completely because it's certainly not been peaceful in any way.
and there's no objects in the legislation itself either, so you don't get that kind. The courts in Australia would not have that kind of guidance in interpreting fair use.
So we insert purpose at a different level, really, in a way, because in the American system, the purpose is sort of an overarching, has almost a meta position to the legislation.
And the courts can use that in interpreting the law, and that the same situation does not arise here, which I think explains why a purposive approach, to sound very legal, might work better in our system.
Okay. I might just make one other point, because there's a lot of talk about the effect on litigation and whether you get a rash of infringement cases, which is sort of one thing. But I think another thing that is important to bear in mind is the role of fair use when you are dealing with a reluctant or difficult licensee. And you find that already with content creators who are trying to negotiate licenses with big online providers who are either saying, we don't think we need a license from you at all, or maybe we do, but we're not going to pay you very much. So if you've got fair use there in the equation as well, that's another thing for a reluctant licensee just to use to say, I don't need a license from you, go away. Or maybe I need one, but I'm not going to pay you very much because I'm going to argue for my fair use discount. So I think that the practical implications, sure, you might see it in litigation through the courts, but more importantly, I think it will come into the licensing negotiations that people are engaging in on a daily basis, and maybe less with sort of traditional licensees, but certainly for new content users when you're trying to set up an arrangement for your content inputs, and they'll be looking for any way to avoid or reduce those licensing arrangements, and that's where we'll end up.
And even more so is it's important to acknowledge that another thing that they have in the US system, which we don't have in Australia, is they have a system of statutory damages. So that's why you sometimes see in the news like extraordinary awards of damages for infringing use of photographs, for example. Now in Australia, you actually have to go and prove your damage in court. There is no automatic amount of damages set by the legislation. So that also very much changes the landscape when you're talking about fair use. It changes the potential risk and liability for a licensee. So in Australia, if we had fair use, there's been no suggestion from any of the recommendations about introducing statutory damages. So we wouldn't have that, nor would we have the guidance of, a Bill of Rights or something in the Constitution.
Right. Well, there is, we will probably wrap up soon, and please, if you have any questions, I do actually have one question which we'll go to in just a moment, but there is actually one tension that I want to get your comment on in relation to fair use. Certainly the Copyright Agency has a very important role in collecting money's remuneration for artists as well as writers. And one of the things that most concerns me when I look at fair use is how Indigenous creative work could be repurposed in a way that really takes it out of its cultural context, but also out of its communal meaning and its communal worth. That without a solid boundary around creative work of that kind, you could be looking at, and this is my, nightmare, you have Kathleen Petjari's, Telstra award-winning painting ending up on tea towels and, mouse pads, and that's transformative. I mean, that's certainly transformative, and it's not a commercial use that is being used by the artists themselves. So what defence could an artist have to say, well, that's never meant to be used in that way under a fair use regime? How would you talk about that? Is there a way of even limiting the notion of fair that would mean that such artists would have their IP protected?
So this raises another interesting distinction between Australian law and the law in the United States, is that we have, in addition to the economic rights, copyright about reproduction, communication, etc., we also have moral rights, which protect a creator's right to artistic integrity and also protect them against false attribution and give a positive right towards attribution. So there is necessarily a tension between how moral rights and fair use work. We already have that to some extent with our fair dealing for parody or satire. So you could have a situation arguably where something was not an infringement of economic rights because it was covered under fair dealing for parody or satire, but it would still be
potentially limited of moral rights.
And I think that is something that a court in Australia would need to have regard to in looking at fairness. Now, in America, they do not have moral rights protection, and part of the reason that they don't have moral rights protection really is because of freedom of expression and how the two work together. So that definitely is a big concern. And there is a broader issue of how well traditional copyright or intellectual property protects Indigenous rights. Yeah. But certainly, in the kind of example you gave, fair use would make it much harder. And for a lot of creative people, there is a value in control of their work. Putting aside the remuneration, they want someone to ask them permission when they use their material. And there are mechanisms for allowing that to happen through Creative Commons and licensing solutions. But a lot of creative people who I deal with, every day at the council across all art forms, really take exception to someone using their stuff without asking, and that, and that's one of the difficulties.
Yeah. I think it is quite difficult, because even though we do have moral rights, which is a entitlement to be attributed and not to have your work treated in a derogatory way, that doesn't knock out fair use. So somebody could still argue that their use was so-called transformative. It's not substituting for something that you're doing yourself, and the more extreme interpretations of fair use use this substitution idea, which is if the mouse pads aren't interfering with the sales of your finer artworks, then too bad for you. And even if you could show moral rights, that doesn't mean that the mouse pads are an infringement of copyright. So I do think it makes it much more.
You could have people walking on sacred artworks in the form of rights.
Yes. Okay, well, I'd like to now go to some of the questions that we've received. And the first one is, has contract override been tested, or is there a precedent here in Australia?
So the Copyright Law Review
expertise.
The Copyright Law Review Committee did a report in 2002-3 on copyright and contract. They actually recommended that the contracts be overridden, but it was quite limited in terms of the exceptions. It was not certainly broad ranging like the PC. There's been some academic work about the extent to which the common law, that is case law, would operate to allow that to happen. I think one of the really significant things is when you think about how business is done, the importance of contract. Contracts usually determine the jurisdiction. So oftentimes in Australia, where consumers are entering contracts where Australian law does not apply. So to some extent it's irrelevant whether or not contracts apply. So there is a question as to what it would actually do in practical terms. My feeling is, again, it would land up in a whole lot of litigation.
Right.
In reality, because that is how, people license rights. I mean, that was one of the most kind of fatuous statements in the Productivity Commission report, when they said licensing is common. I was like, well, how else do you deal in intellectual property?
Yes. Did you have any comment on the contract thing?
I need to say that there were some changes in the UK in 2012. So some of the exceptions in the UK are subject to contract override, but it's still reasonably early days, and so we've made some inquiries there, but we haven't got a clear sense of how that's played out in practice.
And we have another question that's come in as well, which is, given that there is so much institutional pressure for a form of fair use legislation, which would be very damaging to rights holders' interests, how does the book industry best respond? How do we lobby against it entirely, or lobby for a form of fair use with restricted provisions rather than open-ended? Well, maybe I can kind of answer that, Elizabeth. And what we are looking at the moment is developing what our reform agenda is. So we're looking at what users find to be the challenges in the current regime. Now, as with all such things, some of those challenges, some of those issues might not be copyright issues at all, or they might be issues that already have an immediate solution. And it's worth interrogating those independent of all the noise first before we quite identify what our reform agenda is. But the APA is actively working with a committee of largely educational publishers, but not just educational publishers, into the issue of fair use and looking at how we might be able to address some of the challenges that users have identified. So that's what we're doing at the moment. And I should say that everybody can be involved in developing that position, and I would encourage everyone to do so. So unless there are any further questions, and I apologise, I didn't mention at the beginning that you can load questions in the chat section or on the left-hand side of your AnyMeeting platform. But if there aren't any more questions for Libby and Fiona, I'd just like to say thank you very, very much to our speakers today, Libby and Fiona. They have given us a tour of some very complicated arguments and some history that is quite political and at times been very fraught. It's been an exciting time in the copyright sphere, and I hope that you have a better understanding of how some of these proposed changes in the Productivity Commission report that the government is currently contemplating, how it may impact on your businesses. However, if you would like a refresher, or if you would like to revisit our webinar today, we will be loading this up onto the APA YouTube channel and then in the coming weeks. And we will be continuing to engage speakers on copyright throughout the year, so please let us know what issues you would like us to address. And we encourage all our members to engage their customers in discussion around copyright, because we would like to know from them, your customers, what challenges they feel they have around copyright, because I think that is certainly a very critical starting point for some of our discussion. But with that, I'd thank you very much for joining us today. Thank you to our speakers. We've worked them very hard today. And have a safe, happy and restful holiday. Thank you.